Hey, my trendies, trendsetters, and my trendy tribe. Mic check, 1, 2, 1, 2. Let me know if you can hear me. I had to highlight some of the greetings because I'm gonna have to get straight into it because y'all, sound check Annette. Thank you, sound check Annette GL. I can't do the greetings because we have a lot of paperwork to go over today. And I wanted to make sure that I use the time wisely. So a few announcements and then we got to get into it. Okay, hold on. If you were not there for the unboxing of Jay Taylor's candles, y'all, you missed out. I need you to replay it. It was great. He sold out while he was here on the live with me. He was in the chat and he was working. He was busy, but yes. So yes. Go see the unboxing. This is the thumbnail. You will not miss the thumbnail. Okay. Let me see what else. Anything else? Oh, well, that sound reminded me. I think I'm 26 away from celebrating 100 orders. And when I do, I'm doing another giveaway because I love milestones and I like giveaways. So when I get to my first 100 orders, we're doing another giveaway. So now I'm 26 away because I was 27 away earlier. So now I'm 26 orders away. So thank you to the Trinity that just ordered something. Let me see here. Let me pop the trunk. And because I have so much to read, I'll pop the trunk grouped up if I have to pop it again because I don't want to disrupt as we start going through too much, But I'll break it up a little bit because it'll be a lot of reading.
All right, we going. What a money resign. What a money resign. What a money resign. What a money resign.
So thank y'all so much that we're there. Let's see here. Oh, that's Veronica. Veronica, thank you very much for your order, sis. Okay, let's see. Also, check your email. Make sure you're getting your tracking numbers for your orders. And I may have emailed you just to let you know a status if anything abnormal happens. So make sure you're checking your emails. Check your spam folders. You should get tracking numbers within so many days of ordering, because I try to keep everything running as smooth as possible. Okay. I think that'll be all the announcements for now. So let me take this down and let's go to Martell, trash tail, broke tail, bum tail. Okay. Let's see here. Since this one is a little more structured, I won't be able to go I'll be more in the documents on this one because it is it's a lot. And the documents are not in chronological order, but I made myself notes. So I'll be skipping around trying to keep us in the actual timeline that things happened. I just want to let you know, so when you see me skipping around, you understand why. It doesn't look like I'm just going haywire over here. It's a reason. Okay. All right. So let me see what's the page I'm supposed to be on first. All right. And I'm trying to mark it as I go, y'all. I'm trying to stay organized. Okay. So it's in as much order as I had time to get it in. Hey, everybody that has come in. We got a lot of reading to do, so I didn't do individual greetings this time. Okay. So we're going to get started. Sit back and enjoy. If you were there for the Scope versus Zen Gardens depositions, you know how this is about to go. So, if the people come in late and they're like, what's going on? Just let them know, either stay for the part, because I feel like I'm going to fill in the blanks as I go, or, they can go replay, but I just, all of it's going to unfold while we're looking at this. Okay. Last thing I'm going to say, Martell, you never, ever, ever, ever deserve Melody Shari. I want you to know that right now. You was making that whole name trash for a while, a long time ago. Okay, let me see here. And as you see, I got his old literal partner in crime, Dirty Dan, by him on my image, because I felt like that was the most appropriate. Okay, here we go. So we're looking at, first of all, this is the consolidated appearance bond. This is how he got his name, Walkie Talkie. This is not the current case he had a warrant for. This is how he got his name, Walkie Talkie. Shout out to True T. Here for Hot Tea, confirmed. True T did come up with the term. She just loves using it a lot because it's a great name for him. So shout out to True T for the name Walkie Talkie. Look at the maid. Hey, maid. Right. Okay. This is the consolidated appearance bond from the Circuit Court of Morgan, Alabama, for Martell Holt. And then, of course, you see that he signed it. Martell undersigned. He has to pay the state of Alabama the sum of $100,000, and he has to appear before a district court. It'll be to be announced. Let me see here. He has to await action this is all past tense, had to await action by the grand jury for possession of burglary tools. You see, he signed it. This was on January 1st, 2006. So New Year's Day, that's what he had to be doing. January 1st, 2006. Okay. And then notice to defendant and surety upon posting bond for felony cases. So again, you see it's a felony charge for possession of burglary tools. I didn't have time to highlight. I had to try to read and redact as much as I could. So possession of burglary tools. Let's see here. And he, again, January 1st, 2006 is when he signed that. Okay, so now this is where we start skipping pages to try to stay in as much chronological order as possible. So I have to. All right. So this is the complaint by one of the witnesses. It says, before me, the undersigned judge, clerk, magistrate of the district court, Morgan County, Alabama, personally appeared, and that was the witness's name, who being duly sworn deposes and says that he or she has probable cause for believing and does believe that Martell Holt, defendant, whose name is otherwise unknown to the complainant, did within the above named county and did on or about January 1st, 2006, while in Morgan County, Alabama, possess burglary tools in violation of 13A-7-8 of the Code of Alabama against the peace and dignity of the state of Alabama. It was sworn to and subscribed before me this 3rd day of January 2006. All right. Finding my next page. The notes are noting, y'all. Let me see here. And y'all in the chat, if you help me out as more people come in, if they're like, what the heck is going on and what are we reviewing? If y'all could just let them know this is about the Walkie Talkie case, please. Where's my next one? Where are you? Oh, here we go. Okay. All right, this is the warrant. State of Alabama, Morgan County District Court, felony warrant to any lawful officer of the state of Alabama complaining on oath having been made before the magistrate of Morgan County, Alabama, that the offense of possession of burglar's tools has been committed and accusing Martell Holt thereof. You are therefore commanded to forthwith arrest the said Martell Holt and bring him or her before the judge of the District Court of Morgan County, Alabama. Witness my hand this 4th day of January 2006. It says defendant may be released on bail upon his entering into the bond of $100,000. All right. Okay. This is just saying it was transferred to circuit court, just so y'all know. Let me see. Anything else to say on here that we didn't go through so far? Not really on this one, so we'll keep going. There's plenty of pages, so I'm not gonna linger on that one. Okay. All right. Let's see. It says the state of Alabama, Morgan County, the grand jury of said county charges that before the finding of this indictment, Samuel Holt, alias Sam White, alias James Hamilton, Joel Rashawn Carter, Martell Holt, and Deborah Holt, alias Deborah Allen, alias Deborah Eason, alias Deborah Davis, whose names are to the grand jury otherwise unknown, did possess an explosive tool, instrument, or other article, to wit, 1 pair of bolt cutters, 1 pair of 2-way radios, 1 pry bar, 3 ski masks, 1 drill, and 1 pair of pliers, which are adapted, designed, or commonly used for committing or facilitating the commission of an offense involving forcible entry into premises or theft by a physical taking with intent to use the same in the commission of an offense involving forcible entry into premises or theft by a physical taking. All right. See here. And this is the indictment. And they had state witnesses, and it was the indictment for all of their names that I listed above. Okay. Finding my next page. All right. All right. I feel like this is about, yeah, that's about the same. So we can keep going. If you're just coming in, this is about an old case on how Walkie Talkie got his nickname from True T. I just want to keep us on the same page because I know it's a lot that this man could get locked up for because he's a loose cannon, but that's just the one we're talking about right now. Okay, let's see. Where's number 7? 6. Oh, here it goes. It's right above it. Okay. All right. This is the case action summary continuation page. This was May 30th, 2006. It says defendant appears in open court without an attorney and requests the court to appoint an attorney to represent him. The defendant is examined in open court and determined to be indigent. John Sims is appointed to represent the defendant in said case. An indigent, they can't afford an attorney. Defendant waives the reading of the indictment. I'm reading the ones that are checked off. Defendant pleads not guilty. The court grants the defendant 30 days to file pre-arraignment motions. Trial is set on the 23rd day of October 2006 at 9 a.m. Chrissy, hopefully someone can answer that in the chat. He was he was arrested, or his bond was put out there January 1st, 2006. So for the historians that keep up with the dates, Chrissy is asking, was this before he started seeing Mel? because I do not know. Only thing I have in my brain right now is what this case has in here. I don't know anything else. Trial was set for the 23rd day of October 2006. Okay. Done with that part. All right. Then there was an order issued by the court. It says, due to the large number of cases originally set on October 23rd, 2006, trial docket and the setting of a capital unaliving case on this same docket, the trial in the above style case is continued and reset for December 11th, 2006 at 9 a.m. Let's see. This is page 3. Okay. Was I supposed to? I probably skipped on accident. There's a couple other things. Page 8. I'm looking at my notes, y'all. If it gets quiet, I'm just going by my notes. Okay, page 28. All right. So this is an affidavit of substantial hardship and order that Martell basically is claiming. He's claiming a hardship. It said credit card payments, $45. What did it say? I feel like there's something else. So his total monthly expenses apparently added up to $1,343. And then, so basically his total monthly income he was counting was a negative $223. Liquid assets, it says he had a 98 Lincoln Navigator, which he owed about $8,000 on. It says not sure about DMV. I believe that's what the handwritten note says. And it says paid $18,000. So he did a hardship. Okay. Let's see. Page 62. All right. This is an order from the court. This is when he got a court-appointed attorney, I believe. So this says, on timely motion made by appointed counsel John Sims for the approval of overhead office expenses, it is ordered that the request is approved effective as of the date of counsel's appointment, said expenses to be calculated at an hourly rate to be established in the attorney's affidavit attached to the fee declaration, which includes the attorney's certification that office overhead was calculated in accordance with the court standing. Nothing herein shall preclude the ability of the court to approve for good cause shown fees in excess of the maximums. Okay, so that was for the attorney to get his expenses covered. Then we have, is that page 61? All right. Should I be earlier? Hold on. Oh, yeah, page 60 and 61. Okay, then they filed a motion for discovery. That one, I believe, is probably boilerplate. So I'm just showing it so y'all can just see it's in here. I will not subject you to me reading that because it really, I'm pretty sure that's pretty standard for what they want in discovery. So that's just more of a show and tell that is in there. Okay. Then there's an order of discovery that was filed. I feel like there might be something I want to read to y'all in here, but it's not the whole thing. So hold on one second. Let me double check. Okay, no, just showing this file. There's nothing to, I feel like, again, that's probably pretty standard. So I'm leaving that alone. Okay. Let's see. What was page 55? Okay. When do I go to that? Okay. I don't know. I'm making myself a note. All right. Mm-hmm. All right. Then it says, this is where the trial was set for April 30th, 2007. So it was moved from the December 2006 date, continued to April 30th, 2007. All right. Okay. I wonder, I don't know. Okay, this one might be a little out of order, but I'm going to show you the jury's verdict. Then I'm going to go to instructions for the jury from, I think, Martell's side. I just want y'all to know we're not stopping at the verdict. He tried to appeal this. So we're going, verdict, the sentencing. He tried to appeal this just to let you know what's coming up. Okay, so let's see here. So case action summary continuation. So the case was called for trial. The defendant was present with their attorney May 1st, 2007. The state was represented by Brent Craig, assistant district attorney. A jury of 12 having been selected, impaneled, and placed under oath. The presentation of evidence begins. The trial of this case is not concluded and is carried over to May 2nd, 2007. Then we get to May 2nd, 2007. The defendant is present with his attorney, and the state is represented by Mr. Craig. The trial resumes. Testimony and evidence is presented to the court. At the close of all evidence and arguments, the jury is duly instructed regarding the applicable law. A verdict is not reached, and the trial is carried over to May 3rd. On May 3rd, the defendant is present with his attorney, and the state is represented by Mr. Craig. After having completed deliberations, the jury returns to open court and delivers the following verdict, duly signed by the foreman. To the charge of possession of burglar's tools, we, the jury, find the defendant Martell Holt guilty. The court adjudges the defendant guilty of possession of burglar's tools and sets sentencing for August 15th, 2007. The clerk is to provide copies of this order to the district attorney, the defendant, and the defendant's attorney. Okay. Let's see where we are at here. That was 14. Okay, so we're going to go. All right. Again, this is the verdict that I'm sure this is the paper that they hand to the judge is what I'm assuming, possibly. I don't know. But it says verdict up here. And then this is the one. This is either they would have signed the not guilty section or the guilty section. As you can see, they signed the guilty section. So it says verdict to the charge of possession of burglar's tools. We, the jury, find the defendant Martell Holt guilty. And they found him guilty on May 3rd, 2007. Okay. Checking for my next page. If you're just coming in, the files are out of order, so I had to handwrite which pages come next. Okay, I'm going to show you this. This might have been part of his appeal, but I'm going to show you this page just so you can see the instructions that he or his defense attorney had for the jury. It says, I'm not sorry. I am not sorry. It says defendant Martell Holt's request for jury instructions. You are instructed that in this case, a burglary tool is defined as any explosive, tool, instrument, or other article adapted, designed, or commonly used for committing or facilitating the commission of an offense involving forcible entry into premises or theft by a physical taking. You are instructed that a ski cap or any headgear or wear or a police scanner or a two-way radio is not a burglary tool. So Walkie Talkie was trying to get them to define burglary tools and not include the ski cap, the headgear, the police scanner, or the two-way radio as a burglary tool. So that was the instructions to the jury before they had ruled, I believe. Let's see here. Okay, so that was that. 15. Looking for 16. Okay. So page 7. Okay. Sentencing order. Oh, before I read that, let me say thank you for the super chat. And I think someone else had went to the store too. So we're getting in our countdown to our celebrating 100 orders. Janae Miller, thank you for the super sticker. I appreciate you so much. I will pop the trunk before we get to this next document we're about to read. I appreciate both the Trendy that ordered from the store and Janae. Thank you very, very much. Okay.
All right, we going. What a money reside. What a money reside. What a money reside. What a money reside.
Thank you. All right, so now we're on to the sentencing order. August 15th, 2007. Defendant appears in open court with his attorney, John Sims. Defendant having previously been adjudged guilty of possession of burglar's tools. Defendant has received the pre-sentencing probation report. Defendant is asked if he is ready for sentencing and replies in the affirmative. Defendant is asked if he has anything to say before sentence is imposed, and opportunity is given the defendant and counsel to make a statement before sentencing. Defendant, this is where my eyes bucked out, y'all. Defendant is sentenced to 10 years in the state penitentiary. Let me go down. Defendant's sentence is suspended. So the 10 years was suspended, and he is placed on supervised probation for a period of 3 years. Defendant is referred to the Department of Probation and Parole for supervision. As a condition of probation, defendant shall obey all federal, state, and local laws, timely pay the cost of probation and other court-ordered monies, comply with all terms, rules, and regulations set by the probation officer to include attending and completing any DRUG and or alcohol abuse treatment program, participating in and paying for the cost for administering random DRUG and alcohol screening tests, as well as providing DNA samples, and the following special conditions. Defendant is ordered to pay court costs. Defendant is ordered to pay $50 to the victim's compensation fund. Defendant is to reimburse the state the cost of appointed counsel. All payments ordered herein are to be paid per the schedule to be developed by the defendant's probation officer. Defendant is advised he or she has the right to appeal, and that notice of appeal must be filed with the clerk of this court within 42 days from sentencing. And that's why I'm letting y'all know he did appeal. So we're going to look at the at his appeal. Defendant gives oral notice of appeal. So there you go. It's in there too. I guess he verbally said he is going to appeal at that moment when they were recording. The clerk is directed to provide notice of this order to the parties. Okay. All right. Yeah, 10 years. He didn't do it because he completed the probation. But yep, it was for 10 years. We'll look at some of the let me go back and see for the judge's name, y'all, because I wasn't paying attention, Chrissy. Hold on, because she asked, was the judge a woman? Hold on. 1 second. Let me go back to this. Don't want to do the sentencing one. I gotta find a reference document that's good to go by. Let me go back to the one I was just on and see if it's not on there. I don't want to hold everybody up to verify, so I'll just keep going. Let me see. Glenn Thompson is the judge's name. Glenn Thompson. So that's all I have. Okay, page 11. All right. Then there was a motion for return of personal property with Deborah Holt and Samuel Holt, and the defendant's appeal process has concluded or exhausted. They want their personal, it says such personal property was entered into evidence, is not contraband or items that are dangerous to the defendants or the public, that the state is not prejudiced by such release or return of the property. Such property consists of, but is not limited to, person, contents, miscellaneous tools, bank statements and records, shoes, walkie-talkies or radios, or other items of clothing. So that was a motion for return of personal property that was filed. Okay. And that was page 11. Okay. Let's see here. Oops. All right. Let's see. Page. Oh, I'm saying out loud like y'all know what page I'm going to. Hold on. Okay. This is where it's his appeal to Alabama Court of Criminal Appeals, and the sentence imposed was 10 years, suspended, probation for 3 years. The appellant, I can't get it. Appellant attorney Jim Mason. Okay, and then, oops, page 49. So then there was an order made by the court. It says the court, having considered the notice of appeal, appointment of counsel, and request for free transcript of record, it is hereby ordered as follows. Honorable Jim Mason is hereby appointed to represent the defendant on appeal. A transcript of all proceedings in the above numbered case shall be prepared at the state's expense. The clerk shall provide copies of this order to the appropriate parties. And that was on the 22nd day of August 2007. Okay, so he did it within the 45 days. It was, I think, in the same month, possibly. Let me see here. Where's my next? 19. Oh, here we go. Okay. 41. Appellate attorney. It had an NT on there. I thought maybe it wasn't that one. One of them I thought had an NT. It got me. Okay. That word's gonna eat me up for a while because it just has emphasis in different cases, and I'm not there yet. Okay, let's see. Where are we at? I put my finger down, but I feel like that's not where my spot is. Oh, here we go. Okay. All right. It says, this is the notice of appeal. Comes now the defendant in the above captioned matter, Martell Holt, by and through his attorney, and hereby gives notice appeal to the Alabama Court of Criminal Appeals on the conviction and sentence of August 15, 2007 in the above captioned matter. The defendant is indigent and requests an appointed attorney on appeal and free transcript. Okay. And then we're going to, so I might be slightly out of order, but it's not as out of order as it was. Okay, so on this one, I think the main thing I wanted to point out, and I'll go ahead and highlight it so y'all can see it. Let's see here. This is one of the main things I saw, but right here, youthful offender status was denied. So I guess he tried to be seen as a youthful offender. That status was denied. Everything else I think y'all already saw on here. So that was the main thing I wanted to show y'all with this document. I think that was the main. Okay. All right. So then this one is order of probation. It says, it appears to the court the above named defendant has been convicted of possession of burglar's tools and has been sentenced to 3 years. The defendant having applied for the benefits of probation and the court having examined the cause, it is ordered, adjudged, and decreed that the sentence is hereby suspended and that the defendant is placed on probation for a period of 3 years. Okay. All right, so I think that's it for that one. And then this is the Court of Criminal Appeals docketing statement. And it lists his co-defendants again. So this is for Martell Holt. It lists his co-defendants as Samuel Holt, Joel Carter, and Deborah Holt. It was the type of appeal is for a state conviction. And he requested the transcript, as y'all know. Okay. And he wanted a motion for a new trial. It says undersigned counsel was appointed for appeal. The nature of the case is of facts thereof are unknown at present. And it says issues on appeal. It says unknown at present in handwriting. Okay. Okay. This says defendant's post-trial motion for new trial, motion in arrest of judgment, and motion for judgment of acquittal. It says, comes now the defendant in the above styled and numbered cause by and through his undersigned attorney and respectfully petitions this honorable court, alternatively for a new trial for an arrest of judgment or for a judgment of acquittal, and as grounds therefore would show as follows separately and severally, to wit, the verdict of the jury is contrary to the great weight of the evidence in this case. The verdict of the jury is not supported by the evidence in this case beyond a reasonable doubt. The evidence produced upon the trial of this case is insufficient to support a finding of the defendant's guilt beyond a reasonable doubt and a moral certainty. And again, this is Martell and his defense team trying to say there wasn't enough to convict him. The verdict of the jury is contrary to the law. The judgment of the court is contrary to the law. The verdict of the jury is contrary to the great weight and preponderance of the evidence in this case. The judgment of the court is contrary to the great weight and preponderance of the evidence in this case. The defendant has not received a fair and impartial trial. The charging instrument fails to charge an offense. The court is without proper jurisdiction over the defendant. The court lacked personal jurisdiction as to the defendant because the record does not reflect that the defendant was properly arrested. The court erred in overruling the separate and several objections of the defendant to the separate and several questions asked of the witnesses by the state of Alabama during the course of the trial. The court erred in sustaining the separate and several objections of the state of Alabama to the separate and several questions asked of the witnesses during the course of the trial. The court erred in he's saying like it's aired like they actually let me hold on, let me look this up to make sure, because I feel like I know what I was about to say, but I was about to say it like I'm just for sure about something. Hold on one second, let me double check myself. Oops. Okay, yeah. So he's saying the court, when they're saying the court erred, is to make a mistake or do something wrong. I was going to assume that from context clues, but I didn't want to say it. The right talk. The court erred in its rulings on the admissibility of the testimony of the trial of this case. The court erred in its ruling on the admissibility of the physical evidence upon the trial of this case. The court erred in overruling the defendant's motions to suppress the physical evidence and testimony regarding the evidence improperly admitted upon the trial of this case. The court erred in overruling the defendant's motions to suppress any extrajudicial statements and testimony regarding such extrajudicial statements and improperly admitted such evidence at the trial of this cause. The court erred in failing to sever the defendant's trial from the trial of his co-defendants. Does that make sense? If they're your co-defendants, I don't understand it. The defendant was denied his right of due process as guaranteed to him by the Constitution of the United States and by the Constitution of the state of Alabama. When the court failed to sever the trial of his case from the trial of the co-defendants, the court erred in excusing separately and severally members of the veneer excused prior to the striking of a jury. The court erred in failing to issue attachments or otherwise causing to be required to appear veneer members who were summoned and were generally described as being either excused, deferred, or disqualified, which exclusions, deferments, and or qualifications, were contrary to the law with regard separately and severally as to the veneer summoned and from which the grand jury was defectively and improperly drawn, and as to the veneer summoned and from which the petit jury was defectively and improperly struck. I got you, Shan. Okay. The court erred in failing to issue attachments or otherwise causing to be required to appear the veneer members who were summoned and failed to appear with regard separately and severally as to the veneer summoned and from which the grand jury was defectively and improperly drawn, and as to the veneer summoned and from which the petit jury was defectively and improperly struck. The discriminatory method of selecting both the grand and petit juries denied the defendant the fair cross-section of the community guaranteed by both the United States Constitution and the Alabama Constitution of 1901. The discriminatory method of let me see how long does this go. Lord, y'all, he basically every last thing of this case, they said the court made an error on. I will not go look at how far this still goes down. I'm gonna read the summary. The cumulative effects of the errors at trial considered in the aggregate is such that the defendant did not receive a fair and impartial trial. Okay. It says, wherefore, premises considered, defendant respectfully petitions this honorable court alternatively for a new trial, for an arrest of judgment, or for a judgment of acquittal, and request that this court grant him such other further additional or different relief to which he may be entitled. So that's what they submitted. Now I gotta find out which page I was on. Goodness. Okay. Shan started laughing at me. You know, I was like, I'm over it. Okay, then this is the request for a transcript, I believe. He wanted for the trial proceedings and arguments of counsel. So there y'all can see that. Then wrong way. Okay, I feel like that's the same page we looked at before. Some of these had duplicate pages in here. And I will say that the indigency status, he was granted that status at trial court. He was permitted to maybe withdraw an appeal. His status was not revoked. His indigent status was not revoked, and it was his indigent status was granted on appeal. So that might be the most on that one. And post-judgment motions filed. Motion for a new trial was filed. And I think that's good on that one. Okay. Then, let's go 26. All right. So then the court ordered, it says on September 13th, 2007, the defendant by and through his attorney of record filed a post-trial motion for new trial, motion in arrest of judgment, and motion for judgment of acquittal. The court, oh snap. The court has reviewed the defendant's motions, and after review and consideration, said motions are hereby denied. So they're denying. I do want to read that again because that was his appeal. They denied the motion for a new trial, motion for arrest of judgment, and motion for judgment of acquittal. The court denied it. On the 1st of October 2007 is what the date looks like. Is it? Yeah, I think it's the 1st. Okay. And I'll pop the trunk before I go on. Thank you so much to the Trinity that just placed the order. Thank you. Counting it down.
All right, we going. What a money reside. What a money reside. What a money reside. What a money reside.
I'm getting closer to that 100 milestone. Okay. I'm looking for my next page. I promise. My head is down. Okay. Let's see here. Yes, Rose. He thinks he can do wrong and don't be accountable for his wrongdoing. That man got a link missing in that brain. I agree. That's our opinion, and I agree. Definitely do. Okay. So now we are at, the attorney claiming his fees for the hours he put in to defend Martell. This is what this is. I just know some of y'all are curious like me and you like to see some of this stuff. So I'm showing you this too. So he applied for his attorney's fees for the appeal. I think this was for the appeal. Total claim was $330. Let's see. The case was disposed of by accepted into new trial, denied. Okay. Judge Glenn Thompson. Okay. Let's see. Anything else? So that one was so that one was that. So that was one of the attorney's fees that they charged to the court because he was indigent. So it wouldn't be charged to him. Let me see here. 28, 36. Okay, then there was an email sent to her name was Sanja Moody, and it said, "Dear Sanja Moody, the Court of Criminal Appeals has assigned case number, this long number, State of Alabama versus Martell Holt." So I guess she was assigned his case at some point. Okay. Or just maybe she was like the clerk and had to file it. I don't know. Because I feel like it's already been denied at this point, but I'll see if my memory's just not serving me. Oh, Jasmine, keep an eye on it while they're shopping. Do not have your eye off it because you'll get alerts about substitutions. Do you want this instead? Or they'll be like, we can't find it. And you'll have a chance to say, well, can you get this instead? So keep your eye on your Instacart. You got to be involved until you kind of get used to it and know to listen for an alert and stuff. So yeah, refresh and keep your eye on your order. Good luck. Sweet Rose, thank you for the super chats that keep the happy personality. Plus, you work very hard. Thank you, Rose. Thank you so much. He is Sabi. I agree. He's still indigent. I'm sorry. That's our opinion. He is. Okay. What page am I on? Y'all. Oh my gosh. All right, so now we have the Court of Criminal Appeals, State of Alabama. This was November 28th, 2007. Notice, you are hereby notified that the record on appeal in the above referenced cause was filed on November 27, 2007. Because the clerk's certificate of completion is dated November 27, 2007, the appellant's brief is due by December 26, 2007. Should the appellant seek an extension of time for filing the brief, the request for an extension must be made in accordance with the court's policy as set out in the informational notice that was mailed to the appellant when this appeal was docketed. Okay. This is so we can dot our I's and cross our T's, y'all. So that's why, some of these might have a little of the same, but if you know me, you know I got to go through the things. Are the turkeys pregnant? Certificate of judgment. It says, whereas the appeal in the above referenced cause has been duly submitted and considered by the Court of Criminal Appeals, and whereas the judgment indicated below was entered in this cause on March 21st, 2008, affirmed by memorandum, now therefore pursuant to Rule 41 of the Alabama Rules of Appellate Procedure, it is hereby certified that the aforesaid judgment is final. Okay, and did it have a date? I guess it didn't have a... okay, I don't know if it had a date. That might be the date. Okay, I always look for mine. Hey, sis, thank you. So thanks, sis, for all you do. I appreciate so much, not just because I like your laugh. Oh, thank you, T-Talk with your girl. Y'all support my sis, T-Talk with your girl, who is a content creator. Let me mark this, and I can pop the trunk again. Let me mark this real fast. I need to get a new marker in a second. My this thing running out of ink. Okay.
All right, we going. What a money reside. What a money reside. What a money reside. What a money reside.
Okay, now we move on. This page 26, it looks like. Okay, this is another attorney's fee declaration. This is where the attorney's claiming the rest of his fees. So total claim was $2,102 to the court for oh, wait, no, sorry. Total claim of attorney was $2,102, but it says, based on the above, I hereby approve the declaration and claim in the amount of $1,500. So again, because it was basically public defender, the attorney had to go to the court to get paid. All right. We are down to our last, well, not last few pages, but last few types of documents. I'll say that. All right. This one might be one of the longer ones, but I do feel like if this is the one I'm thinking of, y'all will want to see this because I think this is them describing what they found, like the state describing it. We'll read it together and see to make sure. Okay. This was in response to Martell Holt's appeal from how I read it. All right. So here y'all go. Here's the best details we would probably see surrounding why the state believed that they had what they had and they were doing what they needed to be doing. That's how, I'm kind of taking it. Okay. Right, Rose. He did? Oh, nice. Jay Taylor. Thank you. Shout out to Jay Taylor. Y'all go watch that review, that candle review. You won't be disappointed. Okay. So it says the appellant was convicted of possession of burglar's tools. The trial court sentenced him to serve a term of 10 years in prison, but suspended his sentence and placed him on supervised probation for 3 years. The appellant filed a defendant's post-trial motion for new trial, motion in arrest of judgment, and motion for judgment of acquittal, which the trial court summarily denied. This appeal followed. The appellant argues that the state did not present sufficient evidence to support his conviction. Specifically, he contends that the state did not prove that he actually or constructively possessed, quote, burglar's tools, or that he intended to commit a forcible entry or physical taking. And then they're giving the definition. A person commits the crime of possession of burglar's tools if he possesses, and we went over those types of tools, so I won't take y'all through that again. I will read number 2. Intends to use the thing possessed in the commission of an offense of the nature described in subdivision A1 of this section. Hey, sweet sis. Thank you so much, 41 Fit. Thank you. You said back to the bushes. I know you got a lot going on, sis. Thank you so much. That is 41 Fit. She's also a content creator and part of the Mod Squad. I'm gonna make my note to pop the trunk. I'm gonna make a note not to forget. Okay. Let's see. In addressing what constitutes a burglar's tool, quote, if the language of 13A-7-8 were construed to require that burglars' tools be especially manufactured and designed for burglarious purposes, it would be almost impossible to convict because very few, if any, tools are manufactured for burglarious purposes. It is, however, difficult to enumerate any tool used in legitimate industry that cannot be used by burglars. From the bungler to the expert, State versus Heflin, restricting the application of 13A-7-8 to only those tools specifically and especially designed for burglars would emasculate the statute. As this court noted in Burrell, is written in such a way as to include any object and or device that could be used in the commission of an offense involving forcible entry into premises or theft by a physical taking. A few illustrations of items that have been held to constitute burglars' tools are a ball peen hammer, nail prying tool, and screwdriver in Burrell, a tire iron in Petit versus State, a lug wrench in Poole versus State, a hammer and a crescent wrench in McGlon versus State, and a sledgehammer in Scott versus State. This one is, this says White versus State. In deciding whether there is sufficient evidence to support the verdict of the jury and the judgment of the trial court, the evidence must be reviewed in the light most favorable to the prosecution. Conflicting evidence presents a jury question not subject to review on appeal, provided the state's evidence establishes a prima facie, I think it's facie. Oh my gosh. Oh my gosh, y'all. Hold on. I gotta look up how to pronounce this Latin term. Hold on. Prima. Prima facie. Hey, okay. Prima facie. Okay, prima facie case. It says Gun versus State denied. Let's see. The trial court's denial of a motion for a judgment of acquittal must be reviewed by determining whether there existed legal evidence before the jury at the time the motion was made, from which the jury, by fair inference, could have found the appellant guilty. Thomas versus State. In applying this standard, the appellate court will determine only if legal evidence was presented from which the jury could have found the defendant guilty beyond a reasonable doubt. Willis versus State. Thomas v. State, when the evidence raises questions of fact for the jury and such evidence, if believed, is sufficient to sustain a conviction, the denial of a motion for a judgment of acquittal by the trial court does not constitute error. Young v. State and Willis v. State. Breckenridge v. State. In determining the sufficiency of the evidence to sustain the conviction, this court must accept as true the evidence introduced by the state, accord the state all legitimate inferences therefrom, and consider the evidence in the light most favorable to the prosecution. The role of appellate courts is not to say what the facts are. Our role is to judge whether the evidence is legally sufficient to allow submission of an issue for decision to the jury. An appellate court may interfere with the jury's verdict only where it reaches a clear conclusion that the finding and judgment are wrong. Kelly v. State. A verdict on conflicting evidence is conclusive on appeal. Roberson versus State. Where there is ample evidence offered by the state to support a verdict, it should not be overturned, even though the evidence offered by the defendant is in sharp conflict therewith and presents a substantial defense. Fuller v. State, and Fuller v. Alabama, and Granger v. State. Circumstantial evidence alone is enough to support a guilty verdict of the most heinous crime, provided the jury believes beyond a reasonable doubt that the accused is guilty. White v. State. Circumstantial evidence is in no wise considered inferior evidence and is entitled to the same weight as direct evidence, provided it points to the guilt of the accused. Cochran v. State. Affirmed in pertinent part, reversed in part on other grounds. Ex parte Cochran. Circumstantial evidence is not inferior evidence, and it will be given the same weight as direct evidence if it is, along with other evidence, is susceptible a reasonable inference pointing unequivocally to the defendant's guilt. Ward v. State. In reviewing a conviction based in whole or in part on circumstantial evidence, the test to be applied is whether the jury might reasonably find that the evidence excluded every reasonable hypothesis except that of guilt, not whether such evidence excludes every reasonable hypothesis but guilt, but whether a jury might reasonably so conclude. Let's see, it says intent being a state or condition of the mind is rarely, if ever, susceptible of direct or positive proof and must usually be inferred from the facts testified to by witnesses and the circumstances as developed by the evidence. The question of intent is hardly ever capable of direct proof. Such questions are normally questions for the jury. Okay, so this one is Aryang v. State. It says Officer Rick Williams of the Priceville Police Department testified that at approximately 3 a.m. on January 1st, 2006, he was on patrol and noticed suspicious movement behind the Regions Bank. This is specifically, I believe, now about Martell Holt, y'all, that it appeared darker than usual in the area and that he saw two males dressed in dark-colored clothing running through the bank parking lot, that it appeared that they were wearing something over their heads, that the men were carrying items in their hands, but he could not tell what they were, that he got out of his vehicle and pursued the men on foot, that during the pursuit he stumbled, fell, and lost sight of the men, and that he then returned to the bank parking lot. Williams also testified that upon returning to the back of the bank, he found broken lights above the rear door of the bank and saw that the cover of a telephone service box he believed was related to the security system had been removed, that he also noticed a gold Pontiac in the parking lot of a nearby business, that he approached the vehicle and touched the vehicle and touched its hood and it was still warm, and that the vehicle was the only one in the parking lot that did not have any dew on it. He further testified that he saw bolt cutters in the back floorboard, that he called in the license plate number and learned that the vehicle was registered to a rental company in Huntsville, Alabama, that in the trunk of the vehicle he found a bag containing metal cutters, hardened steel wedges, nail pullers, wire cutters, a sledgehammer, a heavy-duty electric drill, titanium drill bits, gloves, and a ski mask. That next to the bag, he found a pry bar and a receipt from the pilot truck stop that indicated that a wheel pin puller had been purchased approximately 45 minutes before the incident. Oh my God, this bum is dumb. The bum is dumb, y'all. And that he also found two other pairs of gloves in that vehicle. Williams testified that while he and Sergeant Ron DeWeese of the Priceville Police Department were with the gold Pontiac, a black Chrysler driven by the appellant pulled up behind his patrol vehicle, that around 2:30 a.m., he had seen that same vehicle parked in the parking lot that was diagonally across from the bank, and that the black vehicle had been facing the bank. He also testified that Deborah Holt, the passenger in the black vehicle, told them she was there to pick up her gold Pontiac, that the appellant gave him permission to search the vehicle, that after he asked for permission to search the vehicle, he noticed that Deborah was barefoot and holding her boots in her arms, that he asked her to get out of the vehicle, and that he told her she could put her boots on first, but she said she would rather not, that when she got out of the vehicle, he asked for the boots, and that Deborah gave him one boot, but threw the other boot back in the black vehicle. Williams further testified that during the search of the vehicle, he found a ski mask, Samuel Holt's identification, and a two-way radio, and that the radio was in the on position and was on channel 22. That's where the 20s come from. That's where the 20-something comes from. He was on channel 22, y'all. That's the origin of the 20s. That he also found a police scanner in the boot Deborah had thrown into the vehicle, and that the scanner was on and operating. He testified that the two men he had seen were later found and brought to the scene, and that one of those men was Samuel Holt. Finally, he testified that later that afternoon, law enforcement officers recovered a purple flashlight, a black ski mask, and a two-way radio identical to the one found in the appellant's vehicle in the yard of a residence on Willowbrook Street. That Willowbrook Street was about 200 yards from the bank and in the area of the foot pursuit, and that the radio was in the on position and on channel 22. I can't. This man is Walkie Talkie. True T gave him the proper name. Investigator Jody King of the Morgan County Sheriff's Department testified that she was working on the morning of January 1st, 2006 with another deputy, Jamie Witt. That while she was on her way home from investigating another robbery case, she stopped to investigate a suspicious vehicle in a McDonald's parking lot. That the restaurant was closed for the evening. That while they were investigating that vehicle, they heard a noise and saw Joel Carter and Samuel Holt scrunched down at the bottom of the embankment of a ditch at the end of the pavement in the parking lot, and that Carter and Holt were wearing dark clothes. The state presented evidence that the McDonald's was approximately 1/2 mile away from the bank. Sergeant Ron DeWeese of the Priceville Police Department testified that he was at the scene investigating the gold vehicle when the appellant and Deborah pulled up in the black vehicle on the morning of January 1st, 2006. That Deborah said she was there to pick up her vehicle and that Deborah pointed at the gold vehicle. Based on the evidence presented, the jury could have reasonably concluded that the items law enforcement officers found in the appellant's vehicle were burglar's tools because they were items that could be used to facilitate the commission of an offense involving a forcible entry or theft by physical taking. Also, based on the totality of the evidence presented, the jury could have reasonably concluded that he constructively possessed the items that were found in the gold vehicle and that those items were burglar's tools. Finally, the jury could have reasonably concluded that the appellant intended to commit a forcible entry or theft by physical taking. Furthermore, the weight and probative value to be given to the evidence, the credibility of the witnesses, the resolution of conflicting testimony, and inferences to be drawn from the evidence are for the jury. Therefore, the appellant's argument is without merit, and we affirm the trial court's judgment. Well. 20-something. So Walkie Talkie and his 20-somethings. Woo. Let's see. So here's the notice. April 4th, 2008. Martell Holt versus State of Alabama. You are hereby notified that on April 4th, 2008, the following action was taken in the above referenced cause by the Court of Criminal Appeals. Application for rehearing overruled. Okay. We're at the finish line, y'all. I got like maybe two other documents. It's not a lot. It says ex parte. This is June 20th, 2008. Ex parte Martell Holt petition for writ of certiorari. I'm so sorry, to the Court of Criminal Appeals. It says writ denied. The above cause having been duly submitted, it is considered in order that the petition for writ certiorari. I'm sorry, y'all. I did not look up that term. Is denied. Okay, and I think that's it. Yeah. I feel like we found a lot out. Woo, child. Okay, family of criminals look deeper. Mama Holt might have a case too. I'm not gonna look up Mama Holt's cases at this time. I need for the people to understand Martell Holt. He's not new to this. He's true to this. We love Bomb Mel. He loved Bomb Mel. She didn't know until they were married. Clowns. Where is the clowns? We need the clowns.
A clown? He's a clown? Why didn't I see it before?
As if the gold car wouldn't stand out. Right, big sis. Certiorari. Thank you, Shan. One of my legal eagles. Thank you, certiorari. But he ain't never been arrested. That's what he be saying. Oh my gosh. Now I didn't name the mama. I named another woman with the last name Holt, but I didn't say his mama. Just so y'all know, I did not name his mama. Just want to make that clear. Yep. Y'all, that was an hour. I'm gonna see y'all tomorrow for Sketchy Saturday, I hope. So come back if you're coming back. I sketch. Y'all can we'll have the panel if y'all want to talk about this case that I read. We can talk about it on Sketchy Saturday. And if you're a member, we are having our part 2 reunion live watch along for Love and Marriage Huntsville. We watch it together. So if you're a member, I'll be dropping that link for y'all. His uncle's wife. Thank you, Gwen. Thank you. Thank you, Muted Expressions. Thank you. Okay. Oh, yes. And we now are probably be 25 or 24 away for the giveaway. I'm not gonna say I just like to celebrate milestones. So just when we get there, for that. But yes, thank you. Joy said don't leave. Those poor babies got carried. That trifling ninja last name. Okay, y'all. I know there's more happening. We're so close to everything going on. I'll see y'all again really soon. Please come back for Sketchy Saturday. Turn on your notifications. If you haven't subscribed, please subscribe. I really appreciate it. If you've been back more than once, go ahead, subscribe. It's okay. Let me pop the trunk for my people. And then I think I'm going to play the thank you for being a friend again because I really like that. So I'm going to play that again on the way out. But thank you so much for your time, y'all. See you out here in these YouTube streets. Bye.
All right, we going. What a money reside. What a money reside. What a money reside. What a money reside.
Thank you for being a friend.
Oh, yeah.
Travel down the road and back again.
Hey, so we started from the bottom, now we're here, girl.
It's true.
Oh, yeah.
Pal and a confidant.
This is my part right here. Ooh, oh. If I did everything, the biggest gift, the biggest. Yeah, thank you for being my friend. Oh, yeah.
I've been taking my time, taking all of your time, yeah. I've been taking my time, taking all of your time, taking all of your time.